My name is Ronaldo Hilton, the chairperson designate from New York City Loft Board, and welcome to our May 10th, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the timely conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-stabilized residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecute parties who violate the Loft Law and the Loft Board rules. Today, this meeting is an extra session held to discuss rulemaking, and we will be focusing our attention on chapters 1 and 2 revisions. We'll pick up our discussion where we left off in April with the proposal for 29 RCNY 2-01 D25. Ms. Balsam will lead this discussion.
Okay, so that's on page 24 of the document. So I think we had wended our way through most of it, but so it's section 3. Which starts at the top and ends at the middle of page 25. So I think it was Mr. Hernandez had a comment about the email address and email if the occupant provides the owner with a current valid email address. So I made that change. Does anybody have any other comments on section 3 of the proposed rule?
I did. I had circulated to you and the board, I guess you had sent a whole host of ideas to make the process better. I was hoping we could speak about those, and I'm most interested in the steps thoughts about them. Unless I'm premature, as to the section number, if possible. No, that was sent by a firm, but it's probably similar to...
It's the same document, I think.
It's similar to what I sent. Yeah.
Okay.
This one page?
Yeah, the singles.
Okay. I'm sorry, I don't know why I don't have it, but that's okay.
You
So-
circulated it?
He did, and I forwarded it. I don't know why I don't have it.
We sent
Okay.
everything.
I
No,
apologize.
that's okay.
So it should have.
And do you have an extra
Extra
copy?
pages.
Yeah.
No.
No,
I
no,
only
I
have,
can use this one.
we have one at the moment.
No, it's okay, I can use this one.
Okay.
None of that pertains to this anyway. That's
Yeah,
all
it's the
section
next
one.
section.
Oh, okay.
I believe it is the next section. So this section, the changes here, other than wording and moving things around a little bit, basically the substantive changes are, I see in the top I have if the owner knows of an email address on the first part. That should be if the occupant provides an email address, I'll change that. Yeah. If the owner knows of, we had decided
yes.
last time that we were going to change those, so I have to change that. In the second section,
Everyone is good with that piece? right?
Where are you?
I am in the first paragraph,
Page 24.
page 24, under V,
Correct.
narrative statement. So it's 1, 2, 3, 4, 5, 6 lines down. If the owner will perform, if the owner knows of an email address, we had decided last time we were going to say if the occupant provides an email address,
Right.
so I need to change that.
So you're just going to conform them.
Conform that, yeah. And then going down the page to E, we're changing, the rule used to read that the owner could be the signator on the narrative statement. We want it to be a licensed design professional, probably the architect usually. So that is a substantive change, and we're recommending that change because it makes sense to have someone who's versed in plans to be the person who is saying that the statement conforms to the plans, and the rest of it is all about service.
On that point, we don't define licensed design professional in the definitions section.
No, it's defined in the construction codes.
Well, if we're defining terms in section, wouldn't it make sense to define it
You could just say,
within our rule?
or you could say as defined in terms. Do that, or incorporate it, I'm not sure.
Either way, I think it's a good idea to define it.
What constitutes architect,
Yeah, registered
Engineer.
architect or engineer.
PE,
New York, first.
right, but that's it,
Yeah.
not a certified interior designer?
No.
Right, yeah, that's, I'm trying to, licensed design professional.
Yeah, we could just take the definitions from the construction code. So you want to put it into, you want to put definition here, or you just want to reference it?
I just want to know first what,
What was?
who, what, yeah.
Yeah, I was thinking of the construction code when I used that language.
Okay,
So we'll add a definition to section 1 for a licensed design professional. And the rest of it is service, so that's, and the narrative statement and filing it with the board. So if we're okay with section 3, we can move on to section 4. And there, I think you do have a comment, right?
Oh, yeah, I was hoping we could take them one by one.
Yeah.
So, the rule currently has the staff, I think, starting to schedule within 30 days a conference. And I'm not sure why you want to not be obligated to actually start the process in a fixed time, given that the owners are under a very tight timeframe.
So the rationale for that is that we didn't always make the 30 days. Now, we could, it doesn't actually say that you have to start it. It says that the conference has to be scheduled within that 30 days, right?
Right.
So it says has been scheduled.
Right.
So it's very rare that we actually schedule a conference within that 30 days.
started.
So, I mean, we could, instead of taking out the 30 days and putting in a reasonable time, we could keep the 30 days but change the end of the sentence to say the Loft Board will contact the owners and occupants to schedule a conference. Because that's really what we are doing. And for the most part, that is a deadline that we make. The problem is that there's just so many people to get together. That's really what it comes down to. Just everybody's schedules don't allow it to happen within 30 days.
Yeah, but so once the contact is made, is there no time frame limitation on when the scheduling has to occur in the actual?
No, but we try and do it as quickly as possible. I mean, we're aware of the code compliance standards, so we try and do it as quickly as possible.
Was that your question?
Yeah, but I mean, I would think there has to be some outside time frame past which you shouldn't be charging the days to the owner under their time frame, right?
Well, we can just leave it as is. I mean,
This is actually section 4, right?
it is section
Right,
4, yeah. So, I mean, I'm okay with leaving it as 30 calendar days if you want to, but I sort of feel that the rules should realistically reflect the process.
Well, then maybe the process should better move things along. I mean, that's my point. Yeah, I mean, so I would ask that you not make this the change on this one that you're proposing.
Can we discuss how it's working these days in terms of scheduling?
I mean, for the most part, we
Detail.
schedule within 30 days, but the conferences are rarely held within 30 days. So, but there have been times that we've missed, and I'm always concerned about missing a deadline in a rule, so.
And in the process of scheduling, is there considerable back and forth?
Yes. I'm going to ask Mr. Bobbitt to address that, because he does most of the scheduling.
Yes.
because you've got to schedule the tenants, the owner, the licensed design professionals, maybe a lawyer or two.
Architects, attorneys, if there's no attorneys, the tenant representative, they're all contacted within 30 days of the notice.
Right. And is there any correlation in the difficulty of scheduling
Yeah.
between the size of the building?
It may take the tenant's attorney a little bit longer to confirm if the date is acceptable because they have no lines to contact, but no, they seem to do it in a reasonable time frame and usually schedule within a few days of the first contact.
And in some buildings, there may be more than one attorney or more than one architect representing the tenants. Okay, but size is not a principal contributing factor to the degree of difficulty. And when you say the landlords or the owners on a tight time frame, can you just expand on that?
They have certain statutory deadlines to meet, after which they can't sue for rent in the event a tenant ceases to pay rent. Is that right? Am I saying that right?
So you're talking about the code compliance
Yeah.
deadline. So these would be people that had, obviously, since everybody's out of compliance unless they have an extension, so you're talking about owners that have obtained extensions, right? Because
Well-
at this point, only newly covered or new owners, right? Newly covered buildings or new owners are going to even be remotely in compliance. But I don't think we should consider that anyway.
Right. My only point is that obviously the Loft board staff should not be taking more time such that it would impede an owner from meeting whatever deadline they might have. And by taking away a fixed time frame and replacing it with a reasonableness standard, that would increase the possibility that the staff could cause a problem. So that's the basis for my wanting to keep with the fixed date as opposed to a softer standard.
But would I be correct to say that for most owners, the problem already exists? It's not that they're out of, it's not, if it takes the staff 40 days instead of 30 days, that's not creating the problem.
That's probably true in most cases, yes.
Yeah, unless it's a new owner or a building that's newly covered, where in either of those scenarios, the owner has been granted an extension.
Okay,
So,
it still could benefit someone
Yes.
by keeping the rule as is.
Is changing the amount of time, just like 60 days, is that beneficial in any way, or is
I
that
think
kind of
that's
like?
worse.
That's worse, okay.
Mr. Carver wants to make it 2 weeks, right?
You know, if you take as much time as you want, if you extend the deadlines on the other side.
Yeah.
I mean, that's.
All right, so we're going to leave it as it is, or is that what this is?
I'm okay with leaving it as is. That's what.
So we're going to keep 30?
Yeah, we'll keep it.
Okay, so my second point is that there's no obligation on the tenant to make an objection until the very end of the process. So the thought is to give hard date deadlines to make objections rather than wait until the very end.
Now, this pertains to the rule as it's currently written, not anything that's changed.
Right.
So, I'm just trying to envision how this would work.
Use or lose?
No, I mean, I think the question is, you know, so you're contemplating inserting something that would say no later than 10 days before the conference, assuming that we have that much time beforehand? The tenant has to file objections or something like that?
Some time frame rather than wait until the very end.
Can you point out the language that you see as controlling this?
I would have to find it.
Oh, that'd be good.
Well, actually, it's an absence of any hard deadline. That's the problem. That's the problem.
Means what?
So, and sort of in layman's terms, Mr. Carter, if I understand what you're saying, you view it as currently the process can be delayed and bogged down simply because
Forever, yes.
the tenant doesn't have any obligation of an area of when they need to start taking action.
Right, right.
Is that accurate?
Um,
Forever is a long time.
They said it's Ken.
So the way that it works now is we have the conference, and the tenants usually do send objections. And then at the end of the process, we start a clock, and when, a 45-day clock. And when the clock is started, that's when the tenants file official comments, and then we could start an alternate plan proceeding. So if I understand what you're saying, Mr. Carver, is you're asking us to not have the clock at the end, but to have some sort of a clock earlier in the process?
Sure, yeah.
The only problem that I see with that, though, is that the plans are constantly evolving until you come to a point where you know they're not going to evolve anymore,
Well,
right?
that's true, but you could still require an objection to that specific set of plans within a certain amount of time.
Some of the issues that might prompt objections from the tenants aren't going to really surface just by examining the plan. Some of it may only be elicited during the conference.
Well, that's okay. I mean, I'm not seeking to bar anyone who has not had an opportunity to object. I'm seeking to bar someone who has had an opportunity, doesn't object, waits until the end, further delaying everything. As I understand it, I mean, I personally have never been involved in one of these conferences.
Is the idea to have the clock start at the end of the conference?
Well, since the paperwork is served on the tenants prior to the conference, that's one possible starting time for a clock. I guess another time would be at the conference.
Well, it seems like the nature of the conference is to discuss the documents and proposals, so it would be rather, I don't know, it seems like it would be an entirely, the conference would be a different kind of meeting if the idea is that all objections must be filed prior to the conference, and then there's just.
It would make it more productive if you knew what the problem was.
If you could have a meeting before the meeting, then you wouldn't need the meeting. I mean, if you could flesh everything out perfectly, then you wouldn't need a conference. But I guess I thought the nature, and I haven't been to a conference, so I thought the nature of the conference was to have a discussion between the parties to be able to flesh things out. So it would be rather difficult. The whole point of the conference is to have that exchange and not to restrict require communication prior to the conference. So I don't really see how you can have the clock start before the conference unless you didn't want to have one. I think it's more reasonable to suggest that at a certain point after the conference that there should be.
Are we talking about cases, instances here where there are multiple conferences?
Well, I don't think it matters one way or the other, multiple conferences or one conference, still, you still have the 45-day clock at the end, and I think that's what the objection is.
It's at the end of the final conference?
Yes.
Really, can't see where there's going to be an objection made after the conference is over and people go home.
No, I think that's the problem.
Well, I sort of think.
Why is that? I can't conceive of that.
Because they don't necessarily reach consensus.
Well, I understand that, but then the conference isn't over if it doesn't reach consensus, is that right? You
Right.
have to reach consensus in order to move to the next step.
Or they don't reach consensus, and we start the clock, and the tenant has a right at that point to file comments on an alternate plan.
I feel a little bit like the old, story of blind men trying to perceive an elephant by feeling various parts. I'm the only board member who's ever been to an area statement conference. Our building had 3 units, so it was a relatively simple, straightforward affair. I guess it would be helpful, and I guess Mr. Babick is the key narrative statement conference convener at this point.
Well, no, actually, we're shifting that, but he has been in the past, so.
He has a lot
He
of
has
experience.
the most experience, yes.
So, is this a problem that comes up a lot, or are we
It's
dealing with a straw man here?
It's a problem that doesn't come up.
It's a problem that has come up.
And some buildings are smoother, other buildings are a little more challenging. More units,
Right.
more challenging in the building.
Does it come up 20% of the time, 80% of
I would
the
say
time?
this comes up, the inability to come to a consensus.
Right,
I would say it happens more often than not.
more often than not.
At the first conference, and plans are then worked on by the owner. They usually include some of the tenant's comments. There may be some issues that are left that are an issue.
Okay, so,
And that's what we would use the alternate plan for. But throughout the course of the process, most of the issues are resolved except for certain situations of the bigger issue.
Could you just come closer? Since it seems like he's coming on the standards.
well, no, we're trying to write.
I meant
Yeah.
There's a
to get
mic over
correct.
Yeah,
there. There.
We're trying to write rules for something that most of us don't know that much
No,
about.
it's just so that he's on the
Yeah.
record.
So, and I think we're also confusing 2 different terms. The conference could include a series of meetings.
Yes,
So the first conference is not a it's the first round of discussions.
there may be one, there's usually more than one. Take 2 or 3.
Right. So the conference in a big sense is a series, could be a series of meetings rather than it all gets done at one time. And it's my understanding that a lot of times for both parties, it may be that issues get raised on the first joinder that leave people to say, oh, I need to think about that, let me go talk to my architect. So the fact that we didn't get to a handshake after the first session is not a weakness in the process.
No, it's just part of the evolution of the legalization plan. Very rarely will you ever get 2 parties to agree on a plan the first time.
Right.
Usually takes another meeting or 2. There's usually communications between the architects through email or through private one-on-one sessions, and the plans are ever evolving. And if another conference is needed to address certain issues that were left open prior, we do that. If we can't reach a consensus, and if there's just nothing left for us to do, that's when we would use the 45-day clock to move it all along. There is the situation where the tenants don't say anything at all before or during the conference, but then have an architect who file alternate plans. That happens. It doesn't happen often. But usually after a few conferences and a few back and forths, the parties come to an agreement.
So have you had experience where no consensus is made, period? And the buildings stay in limbo forever? That's
Well,
not possible, is it?
It's not the building can remain in limbo for a certain period of time.
Sure.
But the process of the alternate plan is to put an end to the process once and for all. And I just want to highlight that we did go through a situation recently with a bigger building where the parties could not reach a consensus, and the law board decided that the best route was to go through an alternate plan, and through the hard work of the parties, they came to an agreement.
In the situations where the tenants did not provide comments about plans, either prior to the initial conference or during the initial conference, and instead hired an architect to review and provide input, what kind of timeline does that usually end up being? When could tenants, architects, plans arrive? Probably a month later after the conference, initial conference, a month.
I would say after the clock, after the law board issues a clock, where it says now, tenant, here's your one last opportunity to put forth a plan, but it's not only drawing a plan, it's also there's a statutory standard for you to meet. But usually after the clock starts, they file an alternate plan or they file comments with the law board.
And the law board starts that clock based on the idea that there has not been activity, so.
Or that we've issued a clock based on no tenants of the building showing up. We've also started a clock where we had multiple conferences and the parties reached the point where they were not going to back down from their position, and the best route was for the alternate plan to start.
If no tenants show up, if you receive no input, no tenants show up to the initial meeting, how long do you wait before you start the clock?
The next day, 2 days. But then you have to remember that the law board can only issue certification until after the owner has cleared the Department of Building protection sheet, and that takes some time. And usually after the first clock, the plans will most likely evolve and will require a second 40-day clock based off of the changes.
Would you just
So,
say that again?
so in a building where the tenants don't show up for a conference, usually it's the very beginning of the process where the owner has his legalization plan. It's his legalization plan. We go to a conference, no tenants show up, the law board starts a 45-day clock based off of the owner's initial filing with the law board.
Provided he's cleared all the objections.
No, but then during the course of the plan examination process, the plans will change. I've never seen an instance where the plans did not change based off of the objections, and based off of those objections, and if that requires a change in scope of work, the law board would have to start another 40-day clock based off of those changes.
Have you ever do you mind if I just?
No, yeah, go ahead.
Have you ever considered, because one of the questions I have is, maybe it makes sense to have the owner clear all the objections before the clock starts? Because it sounds like that first, in the circumstance you just described, it's kind of a faux clock in a way.
I wouldn't necessarily agree. I would say that the owner has put forth a plan, and here you're getting nothing from the tenants. So, why should the tenants have another crack at it of something that they don't like if they're not showing up or filing comments? This way, we have less to deal with, and the owner has less to worry about during the course of clearing his DOB objection sheet and also amending the plans. You only have to deal with those things that have changed since the law board issued the 45-day clock on the initial legalization plan.
And I'm sorry, that in such a scenario, the changes to the plan are based on objections from DOB staff.
Correct.
In order to have it conform to the minimum standards.
So are these rules read to the occupants of this conference before you start the conference? So everyone knows what the clock is?
I usually go through I try to inform them the best I can of what is expected of them at a
Right.
conference and what will happen afterwards.
So,
It sounds like the staff are utilizing the flexibility of starting the clock, as soon as possible, as soon as discussions and exchanges appear to have ceased. If there isn't any discussion at the get-go, there's no input, then the clock starts immediately after the initial conference. Stop me if I got this wrong, and if there's going back and forth and exchanges, and the plans are evolving, and there's continued exchanges and good faith efforts on all parts, then the clock doesn't start because there's no need. That's the
Because
best
we're
we
all
can
into
expect.
consensus.
Right. So, it seems to me that at the end of the day, that's the point of the program, as much as possible. So I think that setting up a clock would actually slow the process down for landlords in certain situations where the tenants are not providing any kind of input. So that wouldn't be helpful for them or for the process. And I don't know if you really want to get into this whole thing where it's like a chess game where everybody keeps on stopping the clock, starting the clock, stopping the clock. It's like, well, I told you I didn't like that door color. Stop. Well, I told you that the door was going to be changed. Stop. So I'm not sure if that's really productive.
No, but of course, right now, we have the possibility, and I think it happens, that nothing is binding the tenants along the way through the process. And then at the end, they have the right to change everything, or at least seek to change everything. So they're not required to produce any objections until the end.
yeah, but don't you think it takes a
With all
while to
fairness to
absorb
the
this information before you file your objections?
No, I'm not saying that they,
Can you actually think of an instance where what Mr. Carver is saying has actually occurred?
From experience, I have not seen, the tenants' comments usually are pretty consistent from the beginning to the end. I would have to say that I haven't seen, I can't think of an instance where
So
they
despite
say
the fact
something
that
and then
what
all of a
he's,
sudden,
despite the fact that what he says has some merit, we really don't even know of an instance where this has actually ever occurred. So it may not necessarily be something that's worthy of really messing with at this point. It's like, okay, so maybe there is an issue here, but it's not actually happening.
yeah, but right now, the state of play is everything is objectionable until the end, and there's no submission of an objection. Why not make it everything is acceptable unless you object?
I think one of the problems is that it sounds like these plans are evolving. So therefore, if we, to burden the Loft Board staff with the idea that they have to parse through, well, you objected to the earlier plan, and the revised plan, you also object. Is the revised plan sufficiently different now that the objection that you're raising now is different from the objection that you raised previously, or it's duplicative? If it's duplicative, then we throw it out, but if it's different, then we have to honor it. I mean, that seems like a very difficult kind of set of standards to try to enforce in a situation where the plans are going to be evolving, are going to be regularly tweaked, presuming that there's a good faith effort involved.
No, but I was thinking not the plan as a whole, but many aspects of the plan would probably be acceptable to everyone, such that you would have to object to the piece of the plan that you don't like at a certain point, or waive it. So, the window width, just off the top of my head, is 30 feet, 30 inches wide. So you could scuttle the whole process at the end if you didn't object to that window width earlier.
But again, we don't really have any, I mean, we can't even think of one scenario where this has really actually ever occurred. I'm inclined to think we shouldn't really, if it's not broke, don't try.
Are the landlords ever object to the plans by their own architect or in the conference?
By their own architect?
Yes.
But the tenant's architect, sure.
No, I'm talking about the landlord.
It's the landlord's plan. So,
But do they ever object to it? I'm asking a question upon, well, they never do. So they're so convinced that whatever is the architect is, that's exactly what they want.
Well, I would
Whether the window was 30 inches or 32 inches, that's fine.
I would assume
Always.
that prior to the conference, they've had a conversation amongst themselves on which way.
Okay.
Remember, the landlord is the driver.
I take my question back.
The architect's the one sitting next door saying, what do you want? I'll point out the direction for you. You know, that's what the architect is. Go ahead.
You see, the only thing is that in my very limited experience, since I had studied architecture, that I have come across, and I've worked in some architectural offices, I've come across instances where architects have drawn plans for specific owners, and they've gone in and looked at it, and they came back and said, no, I think we ought to change it. But you say, this doesn't happen, all right, that's fine.
I think that probably does happen, but it probably happens before they file it at DOB. I would hope it happens before they file it at
Okay.
DOB. Because that's the point where we're jumping in, right? They've already
I
filed
understand,
it all to
sure.
DOB, and then sent us the narrative statement and then we schedule a conference.
Well, I certainly see your point, and I don't want to sort of particularly change the subject here, whether I'll get into this or not. But, you know, I read this, and sometimes I'm saying, what are you saying here? The word, in one instance, is the word applicant, application, and applicable is in one sentence. Now, that's a little nutsy to me. Now, should that be changed? It makes perfectly good sense, but I don't think it's really a very good way of putting it, right? So what I'm saying is that, you know, whatever it is, it's never really in just black and white. All right, you agree, then let's go. Maybe that's what happens in every instance.
could you rephrase that?
I think it would be helpful, Mr. Schachter used the example of door color, Elliot used the example of width of the window. What kind of issues are the things that create disagreement and?
Usually the work that has to be done to the tenant's units, like mezzanines and alcoves, things that will change the layout of their unit, things that would disrupt their lives, disrupt their work. That's usually the things they're objecting to, what they have concerns with.
But it could also be work in common areas. So for example, I was at a conference recently where the owner wanted to alter the stairway, and that was going to affect, it did affect the tenant's space, but you know, that they could probably mediate. But you know, how is the tenant going to get in and out during the construction if they're taking down the stair and it's the only stair? What's going to happen? So, you know, those kinds of things, entrance and egress, I think are big issues also.
Right. And that's my point, that for the most part, I think the objections tend to be material rather than, I'm just objecting to something just to delay the process because I don't like it.
To add, I've seen there's objections about building-wide systems that tenants want to offer their suggestion. And I have seen the other, what you just said, I've seen the other way where they suggest something and that's what they want. But the owner believes that they're, say for a heating system, the tenant owner's putting what they want as their heating system. The tenants are not happy with that heating system, and they want this other boiler, this makeshift system, and that's what they want. So I've seen that hold up the process as well. Not with heat specifically, but owners want to do it this way, tenants wanted to do it that way, and then you're faced with an alternate plan.
But why should we not require a fixed amount of time in which to make that objection once you've seen a plan?
Well, in essence, it's set up that way. That really is how it's set up, right? So you have the conference or conferences, and then you have a fixed amount of time to present that. And I think the problem is that plans evolve. So everybody gets together, there's a conference, and the tenant says, well, I want X, Y, Z, and the owner says, well, we'll have to ask DOB if that's okay. So, here the tenant has voiced something, but the owner can't make that call, it's a DOB call. So then they have to come back together, either in emails or phone, or if we have to, we'll schedule another conference. So,
But if they're objecting to X, Y, Z, why shouldn't they already be bound to A, B, and C, the things that they're not objecting to?
They usually are. They're not raising things that they're agreeing to. They're raising 8 different things that they're not happy with. 4 or 5 of them could be a building-wide system that they're offering a suggestion to, but then the other 3 are, why are you removing my mezzanine? Or why can't I have 3 outposts? Or why can't I have 3 bedrooms?
But what's stopping them from raising that later?
They're not. They're raising it within the first conference. They're saying, I don't want my bedroom like this, or why are you removing my bedroom? Or my kitchen was over here, why are you moving it 5 feet? Or why do I have to have an ADA compliant bathroom?
Okay, so why not ensure, insist, require that objection be raised in a certain amount of time? Otherwise, you waive it. What's wrong with that?
so I would argue that the rule says that already. It's just that that objection is raised at the end, after the conference. I'm still trying to wrap my head around what it is that you're asking us to do. Where do you want the deadline inserted, and what do you think the deadline should be?
A certain number of days or weeks after
From-
service of the narrative statement,
Okay,
with, an extension to the tenant if needed, if they need to retain an architect or someone.
so no narrative statement conference whatsoever.
No, you'll have your conference also, but absent the objection within, to the plan, to an aspect of the plan, the tenant should be deemed to have waived it such that the process can move forward, so that there's no surprise at the end of the process.
You may get 5 pages of things that they should have no reason objecting to, like fire-rated systems of rated wall of the outside building. I mean, in a sense, that's what they're already doing. But I think if I understand correctly, you're asking for a time frame within the date they receive the narrative. That's their time to say, here are my objections.
That's one possibility, right?
Okay, and then here are my objections, then you go to the conference, and those are the only objections they can raise.
That seems like a good idea, actually. That would probably streamline the process.
If we have a situation in which
But they may not understand. I don't think that's.
an owner comes to a conference, sets forth one plan, and then goes to a DOB plan review, and DOB is making an objection and requiring the owner to change that plan. So then, if the tenants are obligated to file whatever comments they must within, let's say, 10 days of the first conference, right? And then 20 days in, the owner has a DOB plan review that he now has to make changes to the plan prior to the next conference. So then in the next conference, are you giving the tenants another 10 days to file whatever comments they must with the changes that the DOB is now requiring? That would be like, we would lose track of all.
Yeah,
Well,
we have a lot of
that was my
policy.
analogy to the chess game, where the,
Start,
Yes.
stop.
you're pressing
So
the
then
clock
we're creating
all
a
the
new-
time.
10 days for the changes that DOB is requiring to a bathroom or a kitchen. we would lose track of all the 10 days.
I mean, we could start a punitive kind of response to owners' failure to provide plans that are ready to be approved by DOB, since they have hired a licensed design professional to do so. So therefore, it could be considered a burden on their part, a reasonable industry expectation that they know how to file something with DOB, and therefore their effort to their failure to provide an appropriate document for the conference is their appropriate basis for a punitive response.
Really, after hiring an architect? Dan?
Absolutely.
Yeah.
It's their responsibility to hire a licensed professional. If they hire somebody who's too incompetent to be able to provide something that DOB can approve, then perhaps that is a problem. Now, if the idea is that we are going to burden the tenants on the basis of their responsibility to act on this document, which has been paid for by the landlord, then we have to hold the landlord responsible for that kind of product. I don't think you want to get into this, but if you want to, we could really start to take out cons for all the participants.
That actually strikes me as quite silly.
I don't think it's silly at all. If the idea is the tenants are supposed to rely on this document, which then proves to be impossible to be relied upon because it is not appropriately done for the legal requirements of the city of New York, then it is an expectation by the DOB that these documents will be done properly.
Yeah, I'm not suggesting that a tenant would be bound.
No, you are
Or a
suggesting
change.
the clock starts based on when they see this document. And if that document is not legal, then we should not be holding them responsible.
I'm not, Dan, I am not suggesting that a tenant would be bound to object to a change that they haven't seen.
No. But you are saying that the clock starts. They need to consistently go and review over and over again every time this process fluctuates back and forth.
So what I'm being told is that there's no extra deadline that should be imposed in this process to streamline it.
I think it's the opposite.
There's
I think the idea
nothing
that
further that can be done.
I think right now what you have is you have the staff exercising their judgment about when to start the clock and doing the best they can.
Mr. Chairman, if I may, we seem to sort of be at an impasse. If I can throw out a suggestion that Mr. Carter craft some language that you perceive that it could be written and bring, obviously we're not going to finish the rules today, there's going to be another rules meeting. Bring back the language and let's actually look at the language that you think may be appropriate for this scenario. I sort of feel we're at an impasse here, and not that I care, I'll sit here till 8 o'clock tonight, but we spent almost the entire first hour just on like two topics. And I'm not saying it's not important.
It's fairly important.
I'm not saying it's not important, please don't misunderstand what I'm saying. I'm saying maybe if we offer you the opportunity to craft the language that you feel could be incorporated, it would be easier for some of us to see your viewpoint a little bit clearer. Just a thought. It's entirely up, just a thought.
Well, let me just get back to what I said a minute ago. We had in one of the rules recently, where two architects were at odds with each other. Remember, it just happened a couple of weeks ago.
No, it didn't.
Huh? Right. So, I mean, what Dan is trying to say is that not every time that something is filed, it's filed absolutely legally. And what you're saying is, once it's filed, that's it. And the objection has to be made with that initial filing, whether it's accepted by DOB or not. And that's not...
I didn't say that at all.
Yeah, but that's what it amounts to when you're saying that this clock has to start with the filing.
With regard to
Of the
aspects that are ultimately approved, obviously, if something's not approved. But let me just ask the staff, because Michael's here, Elaine, is there no additional deadline that would be helpful to move the process along?
I don't want to say that. I would say that there may be, I don't want to say no.
Are you asking him to advise, like, I'm not sure what you asked.
Yeah, I mean, we're here, I mean, this aspect of the rules is open, right? We're trying to improve it. That's the whole point of us doing this
Okay, so he's not a.
renovation. So my question is, for those of you in the trenches who are dealing with the long slog that is an narrow statement process, is there no additional deadline that could be imposed that would help move it along? That's just my question as a member of the board. It's a legitimate question. To the staff who's doing this work and who's asking us to change the rules.
Okay. As someone who attended a few, I don't think it's a bad idea to have the tenants lay out at some point, either before the conference or immediately after the conference, where they've had the opportunity to look at the plans, to sort of lay out for the owner and the loft board what issues that they see. But I think it's barring them from raising other issues and is making us nervous about it. Because it's only after, let's say, the first conference. Perhaps they didn't have an opportunity to see what the owner plans to do with the common areas. They haven't focused on that because they've been focused on the owner's plan to change all the partitions in the unit. I don't think it's a bad idea to have the tenants present to the loft board and to the owner their issues if they know what they are. It's the second half that I think we're having a problem with. That if they don't raise it at that point, then they're forever barred from doing it. The whole point of the process is to engage in a conversation while the plans are evolving with DOB.
And if I could just add, first of all, I just want to say that I don't think that the owner's architect practitioners go out of their way to file things that are not legal. I think that there are just questions of interpretation that
You don't think they're trying to protract the process?
It's creativeness, it's just.
So that's number one. But number two, I think, from my perspective, having been to many narrative statement conferences, it's great if the tenants have an architect and they've had an opportunity to consult with that architect, and the architect has had an opportunity to draft comments on that, but not all tenants have the wherewithal or the resources to hire an architect, to get to it in a timely fashion, and a lot of times they come into the narrative statement conference and they have absolutely no idea of what this is all about. And one of the purposes of the conference is to tell them what the parameters are and what, to give them an opportunity to have a voice, which the law entitles them to. So I think to require them before at least an initial conference to say, well, you got to say what you object to or you're barred, I think is very problematic. Could we then, after an initial conference, could we impose some sort of a deadline? Maybe that could be reasonable, but
Would it be helpful?
I don't know, the issues kind of narrow themselves.
It's not occurring, so why, I think the point is, is this not happening, why are we going there and spending so much time on this? I forgot who brought this up.
Again, well, I said, if it's not broke, why are we trying to fix it? Because nobody can give us even like one scenario where it's ever occurred.
I mean, the narrative statement process is a lengthy process. It's just the nature of what you're doing. You're legalizing a building that's occupied and that will be occupied during construction. So the process is already time-consuming. It's very sensitive because tenants don't want somebody coming into their unit to tell them what to do, and the owner is sensitive to the fact that they no longer have complete control over the building. So the process may be time-consuming, but I don't believe the narrative statement process or the tenants or the owner is the issue. I think it's getting the code compliance and also getting the buildings legalized in a similar track.
In addition, you had mentioned, if I understood correctly, that when you find that the tenants are not actively participating, that's when you start the clock.
Yeah, because we want to.
One reason.
Right. So therefore, that is already happening. I mean, I think that's your goal, or at least, I mean, that was part of the idea, is to ensure that things don't just kind of drift.
Now, let me play off of that statement 1 second and see if this can help move this forward. If there was some sort of language inserted that at the discretion of the Loft Board staff, if they feel that the tenants are deliberately trying to slow the clock and not start over, is there anything like that would?
But they're already doing, they're already exercising that. Just,
Well, I know, it's actually, but I think what Mr. Carver's saying is there's nothing in the language that says that they will exercise that. Is that sort of what again, I'm just looking for a solution
Yeah.
at this point. I still, my personal feeling is that I'm like the chairman, I think we're messing with something that's not broken, but I'm also trying to facilitate some sort of a compromise.
Don't forget, these are rules, right? These are rules. And we can come back and visit something when it's not working and change our rules. I don't know why it's not productive for us to spend this much time on something that's not happening, not a problem.
I'm told this is a problem. I'm told this is a problem. And I'll come back next time with more detail.
Yeah, could you do that?
Yeah.
You know, it was previously, before the new law, that landlords would slow the clock down and hoping that one day, because we had to get the Loft Board recertified by the state every 2 or 3 years. And for years, landlords would just not want to do it and hope that the Loft Board would go away. So now the situation is, from what you say, is exactly different. It seems to me, it seems to me that both the tenants and the landlord want to move that process along as quick as possible. Why would the tenants want to sit there and wait and wait and wait and object until the plans are finally made, living in some kind of, some kind of situation that's not totally to their liking?
You'll have to ask the tenants who handed us handouts last time that said, stop the fast track. That's who you'll have to ask to answer that question. If the
Well,
tenant,
I do believe there is a human nature factor that everybody likes to kind of kick that can down the road. But again, the chairman and I seem to be in agreement on this. We have no real evidence that that's occurring at this point.
Mr. Carver, yeah, your promise to get some examples or some other concrete evidence
yes,
of
but
that.
now let's talk about when the tenants actually file an alternate plan. I believe there's no time frame in which they have to cure the objection.
Actually, there is, it's just that part of the rule isn't being changed. So it's not in the proposal because that section of 201 is staying.
It still survives.
Yeah.
And it's 45 days.
What is it?
45 days, and they have to exercise all reasonable and necessary effort to clear the DOB objections within 45 days, and they may get an extra 15 days.
So we're not changing that.
If I might, there are a number of other aspects of the narrative statement conference process that we haven't touched on yet, but because I know we agreed to start with Mr. Carver's concerns. But coming off of this discussion, one question I have is the way it's currently structured, the narrative statement process begins after the owner files plans, correct?
15 days after.
Right. And it's my understanding, and I could be wrong because this is anecdotal, that almost every alteration application generates objections. So therefore, the notion that what the landlord provides to the Loft Board and the tenants is going to get through the plan objection process unscathed is highly optimistic. Would you agree with that? I'm seeing a nod here.
Yes.
Why then, why not, in the interest of making the process simpler, because the landlord can't move forward and
utilize the building until the objections are answered. Why not look at the aspect of dealing with the narrative statement conference after those objections have been addressed either substantially or in toto?
Because then you have an owner who has gone back and forth to the DOB plan examiner perhaps several times and prepared a set of plans. That makes it even worse, actually.
yeah, I mean,
And they've
it'll
prepared a
make it twice as
set
long.
of plans that could go ahead, and then the first tenants are first looking at them and voicing objections. So,
Not to mention the expense.
and so, and for those owners that are in compliance, the idea is to move the process along so that they can complete it within the code compliance deadlines, complete the process within the code compliance deadlines and have the building legalized. So that would substantially, I think, slow things down.
I think that may be true in some buildings, but not in all, because in a certain way, what you're describing is asking the owner in particular to try to catch two rabbits at one time, which is not an easy thing. Because here I'm going to negotiate with the tenants of my existing plan, but over here I'm dealing with DOB, and oh, the DOB wants me to change this, so I have to change that over there.
I just want to get your position correctly. Are you saying that the owner should come with a complete set of approved plans, or should be no rules that the owner should first get a set of approved plans prior to coming to the narrative statement?
I would say they should at least have performed some kind of triage on the objections.
How, in what regard?
I'm not familiar enough with DOB.
So I don't think what you're saying is a bad idea, it's just...
Well, let me give you an example, okay? Let's assume that the owner files a plan, and for one of the units, the owner is knocking down all the partitions. There's gonna be no bedrooms, no nothing, there's, like a free-floating kitchen, and, I guess the bathroom has to have some sort of enclosure.
And the tenant says,
okay?
I don't want that.
And the DOB, and the owner clears all of the objections on that plan, and then we start the narrative statement conference, and the tenant walks in and says, I have 3 bedrooms, what are you doing? So now the owner has prepared this plan, done all of this work.
No, but he's prepared it to his own liking.
Well, yes, that's exactly what's
Well,
going to happen if that's what we wait, if we wait till the end.
If
That's
we
the whole point.
If we front load the owner's process such that he has to engage with DOB prior to obtaining the tenant input. It's the inverse.
From experience, if an owner has a cleared objection sheet, I'm not sure how likely they are to negotiate with the other side on things that really may not unreasonably interfere with their unit or in their service, but heating systems, it's like there's a back and forth that goes on, and some owners and tenants use one thing to come to an agreement on another
But
thing.
aren't there stuff in our rules that protect that kind of stuff from happening? Like, can they just come and completely tear up the tenant's arrangement?
The tenant would have to argue that it unreasonably interferes with their use of their unit, but the tenant isn't giving the opportunity to make that objection or argument until the owner, under Chuck's scenario, until the owner, I'm sorry, Mr. Delaney's scenario. Until the owner has already filed the plans and cleared the objection sheet.
So therefore, the presumption that it's a human expectation that the more time and effort that the owner invests in the plans prior to tenant input, the less willing that owner is likely to be to modify them, less receptive they will be for tenant input. So it's problematic for the tenants and for the owners.
And you may get more alternate plans because of it. And right now, we may start the clock, but there are not many alternate plans being filed.
And of the ones that are filed, I think maybe in the history of the Loft Board, maybe 1 or 2 have actually come to us for decision.
Okay, so where are we now on this?
All right, no one is interested in my change, except maybe Martha likes a little piece of it.
No, I see some merit to to it, I just can't envision how it would work,
We're
is
just-
really what it comes down to, so.
We
I
want you
mean-
to come back with anecdotes, and we're not sure that the cure is better than the disease.
Okay, I will do that. I would like to bring a PowerPoint.
Well,
Just kidding.
that might not be a bad thing.
That's nice.
Did you?
That was everything, Mr. Carver?
You had one final thing.
On my
And
list.
we're gonna hold you on that, use or lose, that's it.
That's right.
If you don't make the objection now, you will never have another opportunity.
I'm objecting to the rules change in their entirety.
You had a concern to table.
Very wise.
Document, David.
That was my list. I gotta find my list, but I think that was it for my list. Yeah, that's my list.
Thank you.
So far.
I'm gonna give the meeting back to Helene.
Thank you. Okay, so if we can go back to page 25, I guess.
At this point, we kind of, I have a few small comments on section 3.
On section 3,
Yeah, we kind of jumped into Mr. Carver's stuff.
I could have sworn I did, does anyone have any?
Pardon?
I could have sworn I asked whether or not anybody had any other information on section 3.
I was, yeah.
All right. Mr. Lane.
On section 3,
On page 24. It's where we started.
You had some questions about section 2, I also think, Chuck, correct?
Well, we're not dealing with section.
Oh, okay, I'm sorry.
Section 2 is part of chapter 1, so we're not, oh, no, you have questions on section 2?
no.
Oh, okay.
So you had something about incompatible use language in
That's
section 2.
later.
Right,
Oh,
that's,
okay, okay,
yeah,
okay,
that's for after.
gotcha.
On section 3, these are just small. The occupants may examine the alteration application, legalization plan by appointment to the Loft board. I would like to propose that we allow them to make copies. If rather than apply for copies, if I can nowadays, most people just make records by taking pictures with their phone.
Very
Section D.
Section,
D, occupants may examine the alteration application.
There's nothing to prevent them from taking pictures with their phones if they wanted to.
Could we be explicit?
No, no.
No.
I mean, examine it, I mean, it's not preventing them from doing it, so why put it in there? I think.
Right, okay. Then in E, we make mention of the tenant protection plan, which,
This is in the current rule.
right. And my question is, now that we've added a definitional section to chapter 1, is tenant protection plan something that should be defined?
I think that's also defined, so you can go back to
It can be defined just by referencing.
referencing, this is very new also in the recent legislation, so you can just go back to the administrative code.
Do you want me to cross-reference, or do you want?
Yeah, cross-reference.
Cross-reference.
I think it's huge in this new definitions. Talks about what to be included. Yeah, is that all right?
Yeah.
So it would be including the tenant protection plan as defined in section whatever of the administrative.
Yeah. Here, we're, at the end of E, we state, however, the owner must supply electronic copies of all requested documents free of charge, but there's no timing on that.
Is it for?
No, this is when the owner is filing the narrative statement. So the way that it works now is we don't have the owner supplying electronic copies. So the owner files the narrative statement without the plans, and the
Timeline.
tenant has the right to come in and examine the plans and request copies from the owner.
Are you talking the timeline the owner to provide it?
To provide the electronic copies?
Within some period of time.
What's your proposal?
I didn't have a specific, again, I would defer to people who deal with this on a regular basis. I see Mr. Bobbitt at the window answering all kinds of crazy questions.
Well, I mean, it says, the sentence before says the owner must supply such copy within 7 days of service of the request, so I think we could move that sentence down. And that would apply to both hard
And
copies
what's the
and
consequence if the owner doesn't?
there isn't.
There isn't? In our rules.
Well, the word "must" is in there.
So in violation of the law,
Yeah, I guess-
violation of law code.
Yeah, but I don't know that we
But
necessarily
again,
intend
to,
a
if,
penalty for it.
to Mr. Carter's point, if the desire is to move the process forward, then if the owner is slow in providing them, that doesn't expedite.
That doesn't really help.
You know,
By the same token, though, we're not going to impose timelines upon the tenants, or I mean, well, right, if there's a desire amongst some to impose some guidance and timelines amongst tenants, then now we're going to say we're going to start putting some sort of guidelines and timelines on the owners. It kind of seems to me like we have to say.
Well, in this case, it's, may need these documents in order to formulate my objections or concerns. So we're really just looking to make sure that there's
so what are you talking about? A day, 2, 3, 4?
a week.
In a timely fashion? And putting it in a timely fashion doesn't mean anything. So you would have to give a specific time on this. And I don't necessarily disagree with that.
Well, he's agreeable to 7 days, but.
Is that what you said? I'm sorry.
Right, he's agreeable, but
Okay.
the thing is, his question is, what is the consequence of that?
And within a set period of time, and what's the consequence if it's not provided?
I don't know what the consequence, and I kind of outlined over must. And what does must mean? What happens if it's not must? Is there a fine? I was going to ask that question.
Well, is it-
I mean, remember that if the occupant provides the owner with an email address, then the owner is going to be serving a copy of those plans electronically along with the narrative statement. That's the first part. This is just a fail-safe for carrying over the old language in case there's an issue. And there could be occupants that don't have email addresses or don't want to receive electronic copies and want to come in and look at the copies or get a hard copy for themselves. That's what this is all about.
So back to Mr. Delaney's question, what is the consequence of that conveying this section? So is there nothing in our rules then that we could write to say, to charge the owner with violating our rules? That portion of the rule?
Well, that's just going to slow things down.
No, the process goes forward still, it's a violation. Right?
The thought I had was that maybe this would toll the timing of the narrative statement.
So maybe go against the owner's, what's the owner's,
You mean the 30 days?
Yeah.
you mean extend it?
If I need time as the tenant to, remember, the reason that we have this narrative statement conference is if you want to rehab a building and it's vacant, Mr. Owner, you can do it any way you want to. The reason we're in this pickle is because you chose to rent to people before you had the building up to residential C of O standards. So now we're trying to work together on this. I'm happy if you want to take a look at this and get back to us.
No, I'm going to put the same kind of, yeah, could you come back with?
Sure.
I'd like you to just kind of tell us what you really want. the same.
Only you said that maybe people don't have enough, so can we put in supply electronic or hard copy?
It says,
An occupant may request from the owner a reproducible copy of the alteration application or legalization.
Oh, okay.
Right?
Well, but then what does reproducible mean?
You wanted to say hard copy?
Yeah, I think so.
Sure.
hard.
I think that's, well, paper copy?
Sure, sure.
I think that's what it says now. I don't think we changed that, did we?
No, I think it says reducible.
Reproducible, right?
First line to be,
A reproducible copy is a hard copy?
I didn't write this.
Maybe I did. I'm trying to find what it says now.
For what it's worth, if this has any bearing on it, because I actually still deal with an amazingly high number of folks in the city, tenants, that tell me they do not have internet and don't have any way to read email.
They're lying to you. I hate to tell you.
Well,
Yeah, this
I
is,
can only go by what people tell me, but the hard copy factor may not, if reproducible is hard copy, well, that's fine too.
it's actually what the rule says now. The current rule says an occupant may request from the owner a reproducible copy of the alteration application and legalization plan, but we can change that to hard copy or paper copy, or
Reproducible copy is.
it needs a paper
But
copy.
why would we limit it to a paper copy?
No, not limited.
Limiting it. I
No,
think-
no, not
I think-
limited.
I'm saying they can get it
I
if they want
think
to.
reproducible, actually, it's coming back to me now.
Yes.
I think reproducible goes back to the old pre-CAD days that you couldn't photocopy
Oh,
because the blue and the blue melded together. So I think,
We need to change that line.
yeah, it kind of went the way of vinyl records.
so what word would you like? Just tell me what word, not put it in. A copy of the, okay, so just take out the modifier altogether. Okay, so an occupant may request from the owner a copy of the alteration application and legalization plan. Okay,
That's fine.
Yep. On to section 4, in the first paragraph, little 7, the conference may be scheduled in the evening. What's our track record with evening conferences? Does that work well? Is it hard to schedule? Is it lots of overtime for the staff? What's,
I have not scheduled an evening conference, other than one that started at 2 and went into the evening.
all right, yeah.
So I'm sorry, where are you reading?
Third line of section 4, first paragraph.
it's not a problem,
Okay, all right, fine.
and I would prefer to leave it open.
Now, the next question, the next issue I have, and it touches on language in a certain number of areas, is over the years, I have had complaints from tenants that feel that that there were, in essence, ex parte discussions between staff and one party or the other. The complaints about the lack of a recording or minutes. So I'd like to raise that as a general issue, and I'll be happy to suggest language, but I think it would be helpful if we could spend a few minutes discussing that.
So this is not a part of the board's quasi-judicial functions, so you can't really have an ex parte conversation. An ex parte conversation contemplates that there is some sort of an adversarial process going on. This is meant to not be an adversarial process. We do actually take copious notes, and we frequently refer back to our notes to make sure, particularly, that owners have made all of the corrections that they have promised to make.
Are those notes shared with the parties?
No, they're not. They're internal documents, and no, we do not share them with the parties.
So there are no formal minutes taken.
No.
Are the parties allowed to record the conference discussion themselves?
I mean, it's supposed to be, it's like a settlement conference. I mean, the idea is that everybody speaks freely and then you move forward. So you're really not supposed to be recording it, it's not admissible anywhere else, etc.
Yeah, but using the oath model of a settlement conference, if you can't settle, then there's a more formal proceeding. Here, there is no subsequent, more formal proceeding.
Sure there is.
Alternate plans.
It's an alternate plan.
It's an alternate plan.
Yeah.
Again, this is, so the staff's position is that there should not be, that the level of informality, the lack of any set of agreed upon notes. I don't understand, if the staff take notes, I don't understand why there couldn't be, the conference was held on this and such day, here's who was present, this is what was agreed to, ... this is what was left open, ... And
So we had a conference that ran from 2 o'clock in the afternoon until 7:30 at night. Who's going to be typing up that?
I don't know.
Neither do I.
So,
How often, again, how often?
Well, we
No,
have
no, 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 not that. How often is this an issue where you have discrepancies in what's in recollection of what really happens during these friendly, non-statement conferences?
I think it happens from time to time. You folks might hear this concern expressed from one party to the other, so I would ask that question of you.
I mean, has it happened? Yeah. I mean, and when it's happened, we usually go back and we say, well, you know, you should have done this, this, and this. We'll go back to the owner and say, you know, we just did that last year on a building where the owner made certain promises during a conference and did not change the plans the way they were supposed to. We went back to the owner in a so-called ex parte conversation, which is not ex parte because it doesn't meet the definition, and said, you didn't fix this, you said you were going to fix this, and you didn't fix this, and the owner fixed it. So, does it happen? Yeah, but, you know, we try very hard to take good notes, we try very, you know, so it's not that the tenant isn't going to come back and say, well, but the owner said X, Y, and Z. The other thing that I think you have to understand is that not everybody hears the same thing. So a person could make a statement and I hear one thing and a tenant hears another thing. So, you know, that's human nature. I don't know if there's anything you can do about that.
Well, that would suggest that some sort of summary might not be a bad idea.
You need the staff to provide a summary after?
That would be one approach.
Well, I mean, something called action minutes. I tell you, Chuck, there's nothing more boring than to hear a conversation on video that goes on for an hour and a half.
All you have to do is watch this meeting on YouTube.
I know it, but it's incredibly boring because there's a lot of stuff that goes on here that is just unnecessary. You know, just, you know, gobbledygook talk. But on the idea of getting an action minutes into 1 page or 2, I think that sounds reasonable.
But, I mean, I think part of this is we're adding workload for the staff. And so that's a capacity question. We don't want to elongate this process because the staff have to spend more time having fewer meetings because they have to write everything up. Then the other idea is that anything that is then not included in that write-up, in that summary, is then likely to become a source of contention. And then finally, do we have a licensed architect from DOB participating in this meeting?
No.
All right, so, I mean, part of, I think that I would start, maybe this is not the position of others, but I would start with the presumption of good faith efforts on all the participants, which means that, you know, a landlord, an owner might say, I'm going to do this, the tenant might say, how about that? And the owner might say, all right, that sounds like a great idea. Now, maybe the owner then, by definition, is going to try to incorporate the tenant's feedback in a way that can be approved by the city of New York, and perhaps that will then create something that is unforeseen by the tenant. It doesn't mean that the owner was not exercising a good faith effort. So I don't know, publishing this kind of a document by the Loft board, it seems like it's likely to engender more disputes than it's going to help resolve. And I'm not sure if it's really an improvement over the current process. I understand that tenants may find it stressful when they don't see what they thought was negotiated in the document before them. They don't, but presumably fortunately, they're New Yorkers, and so they call up and complain. And they let the Loft board know that this is not what they thought was agreed, and then the board staff, you know, handle it that way. I mean, would it be more efficient if everything was nailed down specifically immediately after the meeting, or if it was all available on YouTube? I'm not sure if it's really that more efficient, but it doesn't seem that way from my perspective.
What's the actual problem that this would solve, Chuck?
There seem to be cases where there are disputes about what was agreed to. Things get lost. There are disagreements after the fact. There have been cases, and I'm thinking back a couple of years now, where I had some tenants complain to me that they felt that the people who are no longer active in the board staff were kind of working with the owner to move things forward. I don't know whether that's true or not, but what I'm...
100% not true.
Pardon?
Not true.
Not true.
100% not true.
What was it? Who were the people? People that...
No, that's the whole point you didn't want to say.
I'm sorry, I just missed something there.
No, and I hear...
People that,
I hear, you know, a considerable amount of feedback about narrative statement conferences sometimes, and I don't accept all of it as being 100% accurate, but there is certainly the feeling that sometimes the ability to be able to record this or somehow memorialize it would be helpful from the tenant perspective.
Can I jump in with an example?
Sure.
Sure. Okay, so we're at a narrative statement conference, and the tenant is upset because the owner wants to take out their closets. And the tenant says, I don't want my closets removed, or if you have to move my closets, I want my closets rebuilt. And the owner, for whatever reason, digs in his or her heels and says, I'm not rebuilding your closets. They need to come out for legalization, and I'm not going to rebuild it. And the Loft board staff says, don't worry, we'll make sure you have closets. Okay? Now, what the Loft board staff meant was file an alternate plan asking for your closets, and it's a diminishment of services if you don't have closets and you had them before. But what the tenant heard was that the owner's plan, before it's certified by the Loft board, must have the closets in it. Okay, so I think that's a good example of a disconnect. So having that conversation recorded would mean nothing, because the Loft board staff still meant one thing, and the tenant still heard something else.
Well, as you recount that, it sounds like what the loft board staff says, we'll make sure you have closets. If you go to the expense of filing alternate plans.
If you file an alternate plan, yes. Well, we're not going to do a sua sponte, we're not allowed to. We're not their advocates, they have to advocate for themselves.
And I take it that this was a circumstance where, for whatever reason, for egress purposes or something else, the closets that existed.
I don't remember exactly.
It wasn't just the landlord.
It was a legalization issue.
It wasn't the
Definitely
landlord
a
just being
Yeah,
smart.
it was a legalization
Yeah,
issue. It's clearly a legalization issue. So, I mean, that I think is a good example of, we meant one thing, the tenant interpreted it a different way, but the tenant still has that right. The tenant has to exercise, tenants have to exercise their rights. We can't do it for them. The process is designed to get everybody on the same page, but ultimately, if you're not on the same page, the tenants have a responsibility to do something. And that's the way the law is, and that's the way the rules are, and I don't see any way around that.
I'm not looking to change the law or the rules. I'm trying to pursue a line of questioning as to whether there's a way,
The process.
that is it possible to emerge with greater clarity among in this case, three parties, the board staff that are conducting the conference, the owner and his or her professionals, and the tenants and their professionals.
I mean, we try and do a synopsis at the end, okay, here's what agreed to, here are the open issues, assuming that it's not like a 5.5-hour conference and everybody's exhausted. But for the most part, we do try and say, okay, here's what was resolved, here's the open issues, but we're not necessarily going to memorialize that. I don't know that there's a reason to memorialize it. It'll be in the owner's plans, and it's either there or not, and if it's not there and we think it should be there, we'll tell the owner to fix it.
So you do have a synopsis?
We try to, yeah.
And it's available?
No. No, it's verbal. It's verbal, and the
just
tenants, of
verbal.
course, are allowed to take notes.
Meaning at the end of the conference, it's kind of summary of what was agreed upon. So at that point, folks need to make it clear for
I
themselves.
think, Chuck is just looking for some sunshine on this thing. Is that right?
Yeah, clarity would be my preferred term, but yeah, I mean, what we're saying is, here's a process that's complicated. Particularly in bigger buildings, you may have more tenants. If you've got more tenants, that increases the odds that you may get one or two who are more likely to have problems comprehending what's being discussed for whatever reason. And as I understand it, nothing's memorialized. If the attorneys says, look, I got a couple tenants, I'm going to need to replay, I can't record it and replay it for them later and say, see, that's what they said, you didn't hear what you heard. It remains a very informal process. So my question, and this line of questioning, is what could be done to, if anything, without being unduly burdensome on the staff, to try to create some kind of thing that everybody walks away with the same stuff on a piece of paper.
See, I don't disagree with you, but on the other hand, you say not burden the staff. This is going to be an additional burden on the staff. I mean, unless somehow we get a little bit more money from the mayor to have somebody to take some action notes there and then write it up and then review it to make sure that that's accurate, because language is terrible. It's very imprecise.
It's supposed to be an informal process. It's like a settlement conference. People are supposed to be able to voice what they want to say without having it written down. That's the whole purpose. It's to foster discussion. And having any kind of a recording or memorialization, I feel, will really inhibit the process. That's my opinion.
Chuck, do you have specific tenants that have made a suggestion that they said they would like to have their matters recorded, or that
Yes.
they would like,
Yeah.
So that's problematic in two ways, that, and Helene already voiced the piece, but once you start recording things, it's going to start, it is actually going to slow down the process quite a bit. Because people are going to start to make sure that what they're asking are actually, you know, recorded correctly, you know, and it's just going to slow down the process. And I understand also about the whole thing about the informality of the thing, but you really open a can of worms also. Another thing slowing down the process, that once people know that the recording is there, or there is some formal notes that's in that conference, they're going to request it every time, just to make sure. You know, even, you know, by chance I hadn't said it, but maybe it's out there and I didn't get what I wanted the first time. I can probably just ask for the recording, or I ask for the notes, and now staff's going to have to review those notes and to verify. You know, you understand where I'm going. It is going to be highly problematic in a lot of ways.
I actually, well, I certainly understand. I've done other tenant meetings unrelated, but, and I certainly would understand sort of the intimidation in the general sense that some tenants may have, that they're kind of outgunned. They may not, you know, I presume not every tenant comes in with an attorney and an architect. And so I think that the more formalizing the structure becomes, the worse the disadvantage for the tenant, because there's then the sense of the cost and the effort that they need to have in order to participate. They need to lawyer up. They need to bring in their design professional. So therefore, I think that would be more of a burden to tenants. And I guess personally, as the system is currently structured, it places a burden on the tenants to follow up with the Loft board staff when they feel that the documents that they've received from the owner do not accurately reflect the meeting, the discussion. So it is a burden, but I think that is less of a burden than if the meeting became, multiple sets of attorneys, multiple sets of architects.
Well, sometimes you have that already in the bigger buildings, which is a topic we haven't gotten to as yet. But to answer your question, Ronaldo, if there were some kind of summary of key points of agreement, and in my mind also a summary of key points where there isn't agreement, while that might take more time in the initial conference, would it save any time down the line when these questions come up and it goes back to the board staff to go through the notes that they keep but don't publish to determine?
Well, let me ask you, sort of going back to Mr. Carver's thoughts about sort of use or lose, is the thought that in effect is the idea that ultimately the benefit would be that somebody could say, here, in paragraph 3, you said that you would do X, Y, and Z, and you didn't, and so therefore, the thought is that there would be a benefit to being able to point to that formal document?
Yes. Because now, in the first example, or one of the examples Helene gave a while ago, when the owner said he was going to do A, B, and C, but didn't do it, it required the tenants to be paying enough attention to realize he didn't do it, and to come back to the board and say, he said he was going to do A, B, and C, and he didn't, now, fix it. So...
Actually, that wasn't my example. That example was that the Loft board staff reviewed their notes and said to the owner,
oh,
you didn't do A, B, and C, fix it.
Okay, all right.
The tenants raised it also, but we raised it too.
Oh, okay. I'm sorry, I misunderstood that.
Yeah.
So, your point about the summary piece, I don't think belongs in the rules.
Okay, I guess just in closing out this discussion for this particular iteration, Mr. Carver's concern is the pace at which this goes. And in my experience, sometimes one party or both parties want to move through it. Other times, both parties are happy to kind of like, oh yeah, we'll have another conference, it might be a couple months, where nobody's in a rush. So I understand timing is an issue. What I've heard from the tenant's concern is wanting a fuller record, which they can't record it, there's no written summary at the moment. And I understand the oath model of a settlement judge trying to resolve the issues without going to a formal hearing and using a different judge for the formal hearing, so whatever was discussed in the settlement conference doesn't taint the formal hearing. And I don't fully accept your notion that the formal procedure here is an alternate plans conference. I think there are other, the submission of alternate plans. I think there are other gray areas that I would like to, that I will continue to advocate to try to find a way to leave all parties closer to being on the same page, because at the moment what you're saying is really there's no page.
There's not supposed to be a page.
Yeah,
That's the whole point.
and I'm not sure I agree with it.
The page that emerges is the final plan. That's the page.
This is not directly related to what Mr. Delaney is asking, but I'm curious if there's any legal concerns here around the fact that a video or something like that may be released to either the owner and the owner's attorney or the tenant and the tenant's attorney. Is there a legal, what would be the legal ramifications of anything like that?
I mean, the rule says that the settlement discussions and the discussions in the conference can't be used for any other purpose, and we're not changing that.
So even if we did look at something, they would have to come to the Loft board and view it there. There wouldn't be any, we'll send you a copy of the video, or we'll send you a copy of the minutes, or am I understanding?
I don't know, it might be foilable, I don't know. I mean, if it's a record kept, if we keep it as a record, then I guess it would be foilable, but it's going to change that. I mean, in essence, what you wind up with is a hearing on the plans.
So,
Yeah,
It's
I'm
not
just
supposed to
curious
be
of
that
legal
way.
what you're saying is that if the video was made available, conference, you can't object to the video, it's too late. Is that what you're saying?
I'm saying that the rule says even if there was a video, you can't use it for
You
any
can't use
purpose. Yeah,
Right.
So-
So in some ways,
But I know we've discussed it,
Okay.
the attorney-client privilege and all these different things. So none of that would really be.
there's no attorney-client privilege, it's
Okay.
a
Okay. I'm just concerned about the
I think
legalities.
the
of
point
video.
here is that when you have these, a record of this, right, that someone could pull and go through and find and kind of prove their case, then that has to come back now, because there's another party who's going to disagree with it. And there's almost going to be, who said that, a hearing on what already happened on the narrative statement conference, because now you have to, you understand? So that's how this whole process
even
is.
if what you say is so, which I absolutely agree with, it is still possible for somebody to look at this thing and then bring a lawsuit, even though the lawsuit is a lawsuit.
well, people can always be
That's right.
lawsuits, I mean, you
Yeah,
know.
well, then somebody has to mediate
Yeah.
what you're hearing on recording and what's he hearing.
That's right, so,
And my point is that everybody could agree as to what was said, right, which goes back to my closets example. Everybody can agree as to what was said. You can look at it and say, but you said.
Yeah, but I
Well,
understood
yeah,
this
but
way.
that was what, yeah. So, but you heard one thing and I meant another thing. So even if you have the recording, you're still going to have discrepancies.
Chuck, is this something you'd be interested in even now that you know that it's not binding on the parties? Or is having a binding nature of this the whole point of it.
I don't view it as binding or not binding. Again, I view it as clarity. And again, particularly in these larger buildings, you know, you got, I'm sorry to keep using my building as an example, but you got 3 units. There's this problem on 3, there's the same problem on 4 and another one, and there's a different problem on 5. And the staging is, yeah, we'll try to do each bathroom in 2 weeks. Very simple. You get to a building with 30, 40, 50 units, it starts to get, in often cases, I believe, multiple attorneys representing the tenants, it starts to get very confusing. So I'm more interested in clarity than I am binding people.
I'm just trying to think of what exactly the harm is if it were taped. I guess the parties would be a little more hardened in their positions.
Yeah.
I mean, I would think that's true.
You know, I'm changing my whole perception of this. There's a very, very famous fight that Niels Bohr, Nobel-winning physicist, had with another physicist at Columbia. They started screaming at each other. The guy got up on the stage, and they practically were fighting. Now, these are 2 scientists dealing with science exactitude. So what I'm saying is that that's what's going to happen. You're going to pick out one sentence, and one sentence says, look, but you said this. And then 10 minutes later says, well, we said this, but however, you know, so I think I agree. I don't know whether this is really going to have any more clarity to us or to the participants involved. I mean, if they come to some kind of agreement, then that's the end of the process.
It's incumbent on the parties so at some point during this discussion to make it very clear as to what was agreed upon, right? Whether it be at the end or during your, when the agreement is made, okay, to just to make it clear, I'm getting in the closet, right? You understand, or some other way, in layman's terms, or however it was said, just to make it clear, their head in front of everyone, just, it's incumbent on everyone just to make it clear for themselves what's agreed.
I sort of recall, and correct me if I'm wrong, Chuck, but you alluded to the fact that not all of the tenants are that savvy to be able, they're there and they're kind of under stress in the whole thing, and their whole thing is that they may not even be hearing every word. Okay, so for them to actually pause and say, now let me understand that I'm understanding this correctly may not be as realistic as, how many of them are actually how many do we, the percentage that actually bring attorneys with them to these, from the tenant's perspective? It's pretty high. I'm actually trying to find some way to kind of come your direction. But
No, I understand.
I mean, if there's an attorney there, they're professionals, and they're going to be inclined to say, now, excuse me for a second, but if I'm understanding this right, my tenant client is going to be entitled to X, Y, Z. But maybe the tenant themselves, because they're not a professional, they're an artisan or whatever, they're not, they're nervous and, what have you. So,
Well, as Ronaldo just said, if there's agreement on X, Y, and Z.
I wasn't demeaning them, I'm just saying that if they're not, if it's not.
No, the word professional by code just means registered design professional, a registered architect, or professional engineer. Right.
Maybe if there are points that are agreed upon, if there are a way to memorialize that which is agreed upon, and it would be something for the staff to consider.
Thank you.
I also think that's not a bad idea if on some sort of major issues, a piece of paper emerges. Would that be so bad? If the staff is saying if that's bad, then I'm not for it, but if it's not a bad idea, maybe we should consider it.
You still want to know who's writing the piece of paper. That's what you want to know.
Well, if the parties have
If there's attorneys on both sides,
at
and
the
they want to
Listen,
write the paper,
if there
then that's a
are
problem.
attorneys are writing, I'm sure. I've never seen an attorney not write. there are writing on all sides, and everyone has their own notes. What I'm saying is that during the process, you know, when a particular agreement is made, and I'm sure that by way of this discussion, I mean, staff's going to be very careful now to make sure that when an agreement is made, that it is reiterated, you know, openly, so that people know this is what was agreed upon, right? And hopefully that is the process. But we can't codify it. Nor can we make this a requirement for staff to take minutes and write minutes down, and minutes have to be published to make sure that it was agreed upon. That's exactly what was said. You understand? It becomes a little...
I do, but I wasn't going on that path. I was thinking of a one-pager on points that actually were agreed upon.
But could you put the closet clause in there, you know, can you please put that in writing?
If it were a major issue-
But just like if there was a major, you know, that.
Well, I mean, take the closet example. If there's a piece of paper that says, these closets have to be removed because it's required for code compliance under section X.
It was.
Right. Tenant was advised that they can bring an alternate plans proceeding to request the owner reconstruct equivalent closets in another portion of the unit, so that it would be clear to the tenant that the onus was on the tenant to make that filing, rather than Michael Bobbick's going to come in with a hammer and build your closets for you. Because that's what I heard.
The only problem I sort of see with that, despite how nice it might sound, is that, again, human nature, oh, if I can get them to put the closets in writing, I want to get them to put the hallway in writing, and I want to get them to put the kitchen in writing. And the next thing you know, they're writing the whole synopsis of the whole meeting, which is what we're saying can't happen. So we might be opening, despite how nice it might sound, if we open the door a little, it might cause the door to get open the whole way, which we really can't, that it's not feasible.
I don't know that it goes that way. I mean, in a way, we're a little bit like the board of governors of a hospital thinking about how things should happen in the operating theater when most of us have never been in the operating theater.
Well, that's why I usually always try to be more inclined to let it to our professionals who have to deal with it on a daily basis, that are accustomed to the process, and trust their judgment for how they handle it, which I know for the most part, that's how we all view it. But I don't like to see us pigeonhole somebody into an area where, oh, I gotta put this in writing every time, if the staffing and ability just simply doesn't exist.
Moving on.
Thank you. That's my turn now.
I think we're done.
Yes.
Before we does that.
Okay. Can I ask a couple more questions on section 4, short stuff?
Question.
C, owner representative presents alteration application, narrative statement, legalization plan, notices of objections issued by the plans examiners. That assumes that by the time the narrative statement conference is scheduled, the plans examiner has provided a preliminary list of objections.
Yes.
I'd like to ask that we consider adding language that, including copies of those objections, which shall be available for the tenants to copy or to have a copy of. Because if the objections are part of what's going to recalibrate the deal, it would be easier for everybody to get to yes if the tenants had a clearer idea what those objections were.
I'm sorry, including copies? Is it?
Including copies of the objections or copies that are available for the tenants to copy.
So basically what you're saying is that you want the owner to have copies available, copies of the objection sheets available at the conference? Is that what you're saying?
Yeah.
Does anybody have an objection to that?
I assume the staff thinks that would be helpful.
I think it's a good idea, yeah. Everyone is looking at you, so.
Why would I object to something that's
I'm just
helpful?
gonna- Thank you.
We just wanted to give you the opportunity, because after that.
All right, so I'll rephrase that.
So,
This meeting is being recorded, I think.
Right.
next up, next we get to D with the timing, where we get into timing issues, so do we save that for the next go around?
First, I just want to say I appreciate everyone's effort in perfecting, in going through these rules, and the diligence that we are putting forward is just going to make it better, make life better. But and so with that, this concludes our May 10th, 2018 meeting. And our next meeting will be held next week, right here, 22 Reed Street, first floor, May 17th at 2 p.m. Board members, please sign and hand in your attendance sheets. Thank you.